Please be seated.
All right. The record will reflect that the jury is back and appropriately seated in the jury box. Ladies and gentlemen, we are ready to continue. At this time, I am going to give you the initial instructions. You have been chosen to decide a criminal charge made by the state of Michigan against one of your fellow citizens. I will now ask you to stand and swear to perform your duty to try the case justly and to reach a true verdict. If your religious beliefs do not permit you to take an oath, you may instead affirm to try the case justly and reach a true verdict. So please stand. Here's your oath. Do each of you solemnly swear or affirm that in this action now before the court, you will justly decide the questions submitted to you, that unless you are discharged by the court from further deliberation, you will render a true verdict, and you will render your verdict only on the evidence introduced and in accordance with the instructions of the court. So help you God. So say, I will. All right, thank you. And you may be seated. We're going to pass along written instructions so that you can follow. I will now explain some of the legal principles you'll need to know in the procedure we will follow in this trial. Okay. The trial follows this procedure. First, the prosecutor makes an opening statement where he gives his theories about the case. The defendant's lawyer does not have to make an opening statement, but he may make an opening statement after the prosecutor makes his, or he may wait until later. These statements are not evidence. They're only meant to help you understand how each side views the case. Next, the prosecutor presents his evidence. The prosecutor may call witnesses to testify and may show you exhibits like documents or objects. The defendant's lawyer has the right to cross-examine the prosecutor's witnesses. After the prosecutor has presented all of his evidence, the defendant's attorney may also offer evidence, but does not have to. By law, the defendant does not have to prove his innocence or produce any evidence. If the defense does call any witnesses, the prosecutor has the right to cross-examine them. The prosecutor may also call witnesses to contradict the testimony of the defense witnesses. After all the evidence has been presented, the prosecutor and the defendant's lawyer will make their closing arguments. Like the opening statements, these are not evidence. They're only meant to help you understand the evidence and the way each side sees the case. You must base your verdict only on the evidence. You've been given a written copy of the instructions I just read to you. You may refer to them during the trial. Since no one can predict the course of a trial, these instructions may change at the end of the trial. At the close of the trial, I will provide you with a copy of my final instructions for your use during deliberations. My responsibilities as the judge in this trial are to make sure the trial is run fairly and efficiently, and to make decisions about evidence, and to instruct you about the law that applies to this case. You must take the law as I give it to you. Nothing I say is meant to reflect my own opinions about the facts of the case. As jurors, you are the ones who will decide this case. Your responsibility as jurors is to decide what the facts of the case are. This is your job and no one else's. You must think about all the evidence and the testimony, and then decide what each piece of evidence means and how important you think it is. This includes how much you believe what each of the witnesses said. What you decide about any fact in this case is final. When it is time for you to decide the case, you're only allowed to consider the evidence that was admitted in the case. Evidence includes only the sworn testimony of witnesses, the exhibits admitted into evidence, and anything else I tell you to consider as evidence. It is your job to decide what the facts of this case are. You must decide which witnesses you believe and how important you think their testimony is. You do not have to accept or reject everything a witness says. You are free to believe all, none, or part of any person's testimony. In deciding which testimony you believe, you should rely on your own common sense and everyday experience. However, in deciding whether you believe a witness's testimony, you must set aside any bias or prejudice that you may have based on the race, gender, or national origin of the witness. There is no fixed set of rules for judging whether you believe a witness, but it may help you to think about these questions. Was the witness able to see or hear clearly? How long was the witness watching or listening? Was anything else going on that might have distracted the witness? Does the witness seem to have a good memory? How does the witness look and act while testifying? Does the witness seem to be making an honest effort to tell the truth, or does the witness seem to evade the questions or argue with the lawyers? Does the witness's age or maturity affect how you judge his or her testimony? Does the witness have any bias or prejudice or any personal interest in how the case is decided? Have there been any promises, threats, suggestions, or other influences that affect how the witness testifies? In general, does the witness have any special reason to tell the truth or any special reason to lie? All in all, how reasonable does the witness's testimony seem when you think about all of the other evidence in the case? The questions the lawyers ask the witnesses are not evidence. Only the answers are evidence. You should not think that something is true just because one of the lawyers asks questions that assume or suggest that it is. I may ask some of the witnesses questions myself. These questions are not meant to reflect my opinion about the evidence. If I ask questions, my only reason would be to ask about things that may not have been fully explored. During the trial, the lawyers may object to certain questions or statements made by the other lawyers or witnesses. I will rule on these objections according to the law. My rulings for or against one side or the other are not meant to reflect my opinions about the facts of the case. Sometimes the lawyers and I will have discussions out of your hearing. Also, while you're in the jury room, I may have to take care of other matters that have nothing to do with this case. Please pay no attention to these interruptions. Sometimes they come unexpectedly, sometimes they can be pretty lengthy, okay? So we do thank you ahead of time for your patience. You must not discuss the case with anyone, including your family or friends. You must not even discuss it with the other jurors until the time comes for you to decide the case. When it is time for you to decide the case, I will send you to the jury room for that purpose. Then you should discuss the case amongst yourselves, but only in the jury room and only when all the jurors are there. When the trial is over, you may, if you wish, discuss the case with anyone. If I call for a recess during the trial, I will either send you back to the jury room or allow you to leave the courtroom on your own and go about your business. But you must not discuss the case with anyone or let anyone discuss it with you or in your presence. If someone tries to do that, tell him or her to stop and explain that as a juror, you are not allowed to discuss the case. If he or she continues, leave and report the incident to me as soon as you return to court. You must not talk to the defendant, the lawyers, or the witnesses about anything at all, even if it has nothing to do with the case, and they must not speak to you. It is very important that you only get information about the case in court when you are acting as the jury and when the defendant, the lawyers, and I are all here. The restrictions I'm about to describe are meant to ensure that the parties get a fair trial. In our judicial system, it is crucial that jurors are not influenced by anything or anyone outside the courtroom. Now that many jurors have easy access to information through handheld devices and other technology, jurors may be tempted to use these devices to learn more about some aspect of the case. But if a juror were to do this, it would harm the parties. The parties' attorneys would have no way of knowing. Also must not research any aspect of the case during the trial. This means research using a cellular phone, computer, or other electronic device to search the internet, as well as research with traditional sources like dictionaries, reference manuals, newspapers, and magazines. You must not investigate the case on your own or conduct any experiments concerning the case, including investigation or experiments using the internet, computers, cellular phones, or other electronic devices. You must not visit the scene of any event at issue in this trial. If it is necessary for you to view or visit the scene, court staff will take you there as a group under court supervision. You must not consider as evidence any personal knowledge you have of the scene. Before your deliberations, you must not discuss this case with anyone, even your fellow jurors. After you begin deliberations, you should discuss the case with your fellow jurors, but you still must not discuss the case with anyone else until I discharge you from jury service. Until I have discharged you from your jury service, you must not share any information about the case by any means, including cellular phones or social media. If you discover a juror has violated my instructions, report it to my bailiff. I don't believe that it is desirable or helpful for you to take notes during this trial. If you take notes, you might not be able to give your full attention to the evidence, so please do not take any notes while you are in the courtroom. Possible penalty should not influence your decision. It is the duty of the judge to fix the penalty within the limits provided by law. I may give you more instructions during the trial, and at the end of the trial, I will give you detailed instructions about the law in this case. You should consider all of my instructions as a connected series. Taken all together, they are the law you must follow. After all the evidence has presented and the lawyers have given you their arguments, I will give you detailed instructions about the rules of law that apply to this case. Then you will go to the jury room to decide on your verdict. A verdict must be unanimous. This means that every juror must agree on it, and it must reflect the individual decision of each juror. It is important for you to keep an open mind and not make a decision about anything in the case until you go to the jury room to decide the case. A person accused of a crime is presumed to be innocent. That means that you must start with the presumption that the defendant is innocent. This presumption continues throughout the trial and entitles the defendant to a verdict of not guilty unless you're satisfied beyond a reasonable doubt that she is guilty. Every crime is made up of parts called elements. The prosecutor must prove each element of the crime beyond a reasonable doubt. The defendant is not required to prove her innocence or to do anything. If you find that the prosecutor has not proven every element beyond a reasonable doubt, then you must find the defendant not guilty. A reasonable doubt is a fair, honest doubt growing out of the evidence or lack of evidence. It is not merely an imaginary or a possible doubt, but a doubt based on reason and common sense. A reasonable doubt is just that, a doubt that is reasonable after a careful and considered examination of the facts and circumstances of this case. Now, the defendant is charged in count 1 with the crime of first-degree premeditated murder. To prove this charge, the prosecutor must prove each of the following elements beyond a reasonable doubt. First, that the defendant caused the death of Tyrone Hassel III. That is, that Tyrone Hassel, it should be the third, died as a result of a gunshot wound or wounds. Second, that the defendant intended to kill Tyrone Hassel III. Third, that this intent to kill was premeditated, that is, thought out beforehand. Fourth, that the killing was deliberate, which means that the defendant considered the pros and cons of the killing and thought about and chose her actions before she did it. There must have been real and substantial reflection for long enough to give a reasonable person a chance to think twice about the intent to kill. The law does not say how much time is needed. It is for you to decide if enough time passed under the circumstances of this case. The killing cannot be the result of a sudden impulse, without thought or reflection. The defendant is charged in count 2 with the crime of conspiracy to commit first-degree premeditated murder. Anyone who knowingly agrees with someone else to commit first-degree premeditated murder is guilty of conspiracy. To prove the defendant's guilt, the prosecutor must prove each of the following elements beyond a reasonable doubt. First, that the defendant and someone else knowingly agreed to commit first-degree premeditated murder. Second, that the defendant specifically intended to commit or help commit that crime. Third, that this agreement took place or continued during the period from February 1st, 2018 to December 31st, 2018. The crime of first-degree premeditated murder has been defined above. You must think about all the evidence in deciding what the defendant's state of mind was at the time of the alleged killing. The defendant's state of mind may be inferred from the kind of weapon used, the type of wounds inflicted, the acts and words of the defendant, and any other circumstances surrounding the alleged killing. You may infer that the defendant intended to kill if she used a dangerous weapon in a way that was likely to cause death. Likewise, you may infer that the defendant intended the usual results that follow from the use of a dangerous weapon. A gun is a dangerous weapon. A dangerous weapon is any instrument that is used in a way that is likely to cause serious physical injury or death. Premeditation and deliberation may be inferred from any actions of the defendant which show planning or from any other circumstances surrounding the killing. The prosecutor need not prove a motive for the killing, but you may consider evidence of motive in deciding if there was premeditation and deliberation. Motive by itself does not prove premeditation and deliberation. In this case, the defendant is charged with committing first-degree murder or intentionally assisting someone else in committing it. Anyone who intentionally assists, procures, counsels, aids, or abets someone else in committing a crime is as guilty as the person who directly commits it and can be convicted of that crime as an aider and abetter. To prove this charge, the prosecutor must prove each of the following elements beyond a reasonable doubt. First, that the alleged crime was actually committed, either by the defendant or someone else. It does not matter whether anyone else has been convicted of the crime. Second, that before or during the crime, the defendant did something to assist, procure, counsel, aid, or abet in the commission of the crime. Third, at the time, The defendant must have intended the commission of the crime alleged, or must have known that the other person intended its commission, or that the crime alleged was a natural and probable consequence of the commission of the crime intended.